Good morning, everyone. My name is Jackson Friedman. I'm the Policy and Education Coordinator for the BC Nonprofit Housing Association, and I will be your moderator today. I'd like to welcome you to this morning's webinar, Conflict Resolution and the Residential Tenancy Act, facilitated by Hunter Boucher of LandlordBC and Amanda Seminoff of Mediate BC. The webinar is being presented by BCMPHA in partnership with LandlordBC and Mediate BC. We'd like to acknowledge that this webinar is being delivered from various locations on the unceded traditional territories of the Coast Salish people, home of the Musqueam, Squamish, and Tsleil-Waututh nations. We acknowledge that many of you are currently located in the ancestral homelands of Indigenous peoples across the province, each with their own unique traditions and history. At this point, if you have any technical questions or issues, please visit the GoToWebinar support link at support.goto.com/webinar. And before we begin, I'll give you a brief outline of the format. It'll be the presentation will be approximately 45 minutes, followed by an open question and answer period. And our goal is to finish up by around 11:30. At any point during the session, please feel free to type in your questions using the chat feature. We'll then do our best to address as many as we can during the open Q&A segment. The webinar is being recorded and the audience will be muted, which means that you can hear us, but we won't be able to hear you. So again, please type in your questions using the chat feature. A recording of this webinar will be sent out within a day or so, and you'll be able to access the PowerPoint there, so you don't have to worry if you missed something today. At the end of the session, we'll also send out a quick evaluation survey to everyone, and we'd appreciate you taking a minute or so to complete it. Before we start the presentation, I'd also like to extend a big thank you to our BCNPHA education partners, whose support has enabled online professional development opportunities for the community housing sector, and you'll see some of those on this slide here. Thanks, Hunter. I'd now like to introduce our presenters. Hunter Boucher is the Director of Operations at LandlordBC with over 12 years of experience working with the rental housing industry, with a background and expertise in legislative issues and industry best practices. Hunter has taken on many roles within LandlordBC, including the development of our robust webinar series, presenting at various workshops across the province, and managing LandlordBC's legislative helpline. As manager of the new quarantine conflict resolution service, Amanda Seminoff is engaged in all aspects of service delivery, from program design through to conducting mediations. Amanda has considerable expertise in online mediation. She has shifted her focus from startup, tech, and co-founder conflicts to the conflicts arising from isolation and quarantine. Amanda has 2 school-age children and is juggling the setup of this program with the same challenges that many other families face in supporting children who are suddenly out of school, mourning the suspension of their hockey and lacrosse seasons. I'll now turn the presentation over to them. Thanks very much.
Thank you. So thank you for that introduction. I'm going to begin today's presentation on conflict resolution and the Residential Tenancy Act with a focus on the Residential Tenancy Act. As mentioned, my name is Hunter Boucher. I'm with LandlordBC. LandlordBC is a not-for-profit organization that represents landlords and property managers across the province. And our primary goal is education. And we do that through webinars ourselves. So you can go to our website, LandlordBC, and find information about our upcoming webinars, sign up for our e-news to keep up to date with industry changes, which clearly right now, there are a lot of industry changes. So what we're going to focus on today is definitely something that has changed over the last several months. COVID-19 has introduced a series of significant shifts in the way we look at residential tenancies and how we deal with issues that arise during a residential tenancy. There's a ministerial order that is in place that essentially stops the majority of evictions to occur. And from a residential tenancy standpoint, landlords don't have a ton of tools available. The biggest tool that the landlord has available in their toolkit really is an end of tenancy. And it's unfortunate that's what it is, because that's not what people should be in the business of doing. But at the end of the day, that is really one of the few things that is available to landlords to deal with difficult situations. But there are a few other things that can be dealt with that you can use to deal with this. So we need to know what your options are. And before you get into knowing your options, we need to start with documenting. So when an issue arises, we're gonna look at one type of situation right now. We'll say that you have a tenant who is maybe not respecting the fact that we need to be distancing ourselves from each other, at least physically distancing ourselves. Hopefully not actually socially distancing, as they say, but physically distancing, and perhaps we're having guests over on a regular basis. Things like that, where it's potentially causing problems for other tenants. We need to document the issue. No matter how serious or how minor the issue is, should always start with documentation. Whether you've witnessed it, which is perfectly fine. If you witness something, then document that you saw this thing on this date. If someone else saw it or has a complaint, then get them to document and provide that to you. We then need to interrogate the situation, not the tenant. We're not turning a bright lamp on them and interrogating them. We're interrogating the situation. We're trying to determine what is the issue at the heart of what's happening. What do we know about this situation, and how is it affecting us? How does it affect the building? How does it affect the other tenants? How does it affect me as staff? How does it affect the reputation of my company? How does it affect the rental unit? So dig into the situation and fully grasp it before you choose your course of action. So document it and interrogate the situation to really understand what step you need to take next. And that's important whether we're talking about now in the time of COVID-19 or in more, let's say, normal times. You always need to interrogate the situation to be able to take the appropriate action. So we're going to go through what we feel are the appropriate actions. And not every situation is going to apply to this, but I think most are going to apply in this case. So the options that we really see are do nothing, discuss it with the tenant, provide caution to the tenant, perhaps, mediate, which I'm not going to get into great detail. That's going to be later on in the presentation today. Dispute resolution, which is different from mediation in that it is managed by the residential tenancy branch. And then when we may need to involve the police. You'll notice that end of tenancy is not on here. It's not that that's completely off the table. We'll get to that in a little bit. So looking at each one of these, we have to determine, we go back to what we said. How does this affect me or my staff? How does this affect other residents? How does it affect the rental unit or building? And how does it affect the neighborhood? And again, before we move forward, you might decide that, yeah, maybe this is a bit of a nuisance. This is a minor issue, but it's not really even worth mentioning. So stop before you move forward and before you talk to the tenant. Stop and consider those things. How much of an impact is this? Did someone complain about the smell of cooking from someone else's unit? Is that all this is? Which, if that's the case and you smelt it, and yeah, it's maybe not the greatest smell, but maybe not something actually worth discussing. And the reason we say do nothing and having this on your list of possible actions is that it is a very legitimate step in dealing with the situation. Sometimes the solution is to do nothing. And to do nothing perhaps means that you don't escalate the situation. And that's an important part in conflict management, is to never escalate the situation or try to avoid escalating the situation. So doing nothing is a really important tool, and knowing when to use it is really important. It's really easy for us to just immediately say, oh, okay, well, I'm going to move to the first legal step, which is perhaps giving a caution notice. But sometimes doing nothing is perfectly fine. Discussing it is the next step. So if it really is enough of a nuisance that you feel that mentioning it is necessary, and an example of a situation like that is perhaps they do have a guest over every now and again, and you're a little concerned about that. That's a guest that's coming in through the common areas. Or perhaps they are tenants who like to wake up every morning and make a smoothie, and they make their smoothie at 5 a.m. though, with their blender going, and that's disrupting the other tenants around them who are still trying to sleep at 5 a.m. like normal people. Well, the truth of the matter is that that might be something where you just have a conversation. Mention to the tenant, hey, by the way, we've noticed that this is happening. I'm sure they're delicious, but could you perhaps make your smoothies a little bit later? Is there a way to make them the night in advance so you're not running your blender at 5 a.m.? So having a conversation is really, really important. And it can be informal. It's a very valid tool to simply have an informal conversation with your tenant. But the conversation itself is not really worth anything if it's not then follow up with something in writing. So if you have a conversation with someone about something that they're doing that is perhaps causing a disruption, or they're being rude to another tenant, for example, and so you go and you have a conversation, follow it up in writing. Even if it's just an email that you send to the tenant saying, thank you for your time the other day. I'm glad we were able to discuss this. Just a follow-up. Here's what we discussed. So it's simply a follow-up. You can go further than that as well. If it's something where agreements have been made about something and it's serious enough that you feel that you should take the next step, you might choose to then move on to putting something in writing and having the tenant sign it as well. And again, that's perfectly fine. And that's a good step to take to ensure that everyone's on the same page. And you can go back to that document later on saying, well, you did agree. This is what we both signed on. So, if they've been having guests over and they agreed, okay, we'll stop having guests over during this pandemic, and they signed that and they continue to have guests, you can go back to them and say, listen, you did sign this. This is something that you agreed to. And hopefully that is successful with them simply signing something. It might not be, but it is a step in the right direction. The next step is issuing a caution notice. And it goes by a few different names. It might be caution notice, it might be breach notice, warning, final warning, whatever you want to call it. Through LandlordBC, we have a form that's specifically called caution notice. And a caution notice is the last step before you get to a notice to end tenancy. It's a very useful tool. And it's something that is written in the Residential Tenancy Act. If you go to the Residential Tenancy Act and look at how a tenancy ends, it talks about providing written warning in advance. So that written warning, it has precedent in the Residential Tenancy Act itself. Through our experience and through dealing with the residential tenancy branch on a regular basis, a caution notice should have the following things. It should say what the issue is, how the issue can be resolved, when the issue should be resolved by, and what the consequences. What are the consequences if this issue is not resolved? So when we look at this caution notice and what a caution notice should be, again, we start with what is the issue. So describing what has occurred. So if a tenant is arguing with another tenant and is disrupting the quiet enjoyment of the occupants of the building, if they're having guests over and they perhaps shouldn't be, if they're perhaps damaging the rental unit, and we focus a little bit on how it affects other people, but maybe it's affecting the unit itself. They're causing some of the damage. This is the way that you would address that. So you'd say what the issue is. So the issue is, tenant, you've caused significant damage to the property. We'll get into very significant damage a little later. But if they've caused some damage to the property, and it looks like it was perhaps maybe an accident, or maybe it was somewhat on purpose, or maybe through their negligence, explain that. Explain how the issue can be resolved, which might simply be that they stop that specific action or they repair that thing. And then when should the issue be resolved by? So this can be a little more difficult to understand when an issue should be resolved by. It requires that you really kind of get outside of your own head and try to put yourself in your tenant's position. Even if you have that really, really difficult tenant who you just don't relate to on any level whatsoever, but you still have to get out of your head and try to think about how is it reasonable for them to resolve this issue in a specific time frame. So if perhaps what they're doing is that the unit is a significant mess, there's dirt everywhere, they haven't vacuumed in months, there's dishes piling up. Aside from them just living in a certain way, there obviously could be potential damage or risk to the property in situations like that. It might attract vermin or pests. Not cleaning carpets on a regular basis also can have caused damage. There might be fire risks if things are up against heaters and things like that. So in a situation like that, you would write out again what the issue is, how to resolve the issue, and then consider how long it would take for them to clean the unit. I mean, obviously you would like it done tomorrow, but it might be that might not be reasonable. It might be that either you need to give them a week or 2 weeks to resolve the issue. It's best to always kind of go on the safe side. Don't go with necessarily what you want, which we all know what you want is for the issue to likely be resolved tomorrow. Go with something that's reasonable, because if you end up at a later step, which is dispute resolution, and you didn't give a reasonable amount of time, your whole process might be stopped at that, and you might have to start over. So it's really important to be reasonable up front, and perhaps even a little beyond reasonable sometimes, a bit generous in the time that you give to a tenant. And then explaining what the consequences are if the issue is not resolved. A warning really has no value if it doesn't explain what's going to happen if a tenant doesn't follow through with this. And we've seen this, unfortunately, time after time, where a warning was given to a tenant, but then it simply said, this is the issue. Perhaps didn't even provide a time frame to resolve the issue by. But even if it did, if it doesn't say what's going to happen, which is that the tenancy might come to an end. And even in the time of COVID-19, that can still be a very valuable thing. We can't end tenancy right now, but at some point in time, we may be able to end tenancy. And while we'd like to do everything we can to avoid that, the reality is that some tenancies will come to an end. And that is, again, at the end, we mentioned, sometimes the only tool that you may have. So explaining what the consequences are should the issue not be resolved is incredibly important. You may also choose to offer mediation. And I'm going to leave that to the next section. I'm simply mentioning that it is a tool that you have. I'm not going to get into the details here. Calling the police is something that can be a very valid tool. You have to be careful about it. It has to be well thought out. You have to go back to what we said before. How is this affecting myself or my staff? How is it affecting the building or the neighborhood? How is it affecting other tenants or occupants, the rental unit itself? And if in the end, what you find is that this is a violent situation, for example, so you have a tenant who is perhaps has attacked another tenant, which is a sad reality that some of us may experience. You may witness this. Then that would be a situation where you may want to call the police. You probably would want to call the police, in fact, in that situation. Someone is being assaulted. So you have to really consider the severity of the situation before contacting the police. And there's a variety of reasons why you need to do that. First of all, you don't want to waste the time of your local police force. So if it's not something that requires the police, but it's perhaps, again, an annoyance, perhaps maybe even mildly unlawful. There is such thing as mildly unlawful. Then perhaps don't call the police. But if it is a significant thing, then definitely contact the police. And again, like I said, always consider that, because one of the other things, the other side effects of calling the police is that may escalate the situation further. And in this time that we live in, with the difficulty to end tenancies, escalating a situation further and causing the tenant to perhaps act out even more is obviously something we really want to avoid, because our tools are limited at this time. So again, it is a valid thing. So we then look at dispute resolution. And its dispute resolution is a process that is provided by the residential tenancy branch. It essentially allows a landlord and tenant to come together on a phone call to discuss a situation and have a third party come to a decision. It's very similar to mediation, but the difference being is that in dispute resolution, the rules that an arbitrator are bound by are very much tied to the Residential Tenancy Act. They're very limited in the types of decisions that they can make, and their mediation, they're trying to come to an agreement. Those skills are perhaps not as robust as a third-party mediator might be. It is their job to try to come to mutual ground for both parties, but they're not always, that's not always necessarily their primary focus. Sometimes it's simply just writing a decision one way or the other about how they feel something should go. So what does dispute resolution get you? Why is it worth it? Well, there's three possible options that can come out of dispute resolution: an order to comply, a monetary order, or an order of possession. So when we look at an order to comply, what does that mean? Well, it means that you can have an order from the residential tenancy branch that states that the tenant needs to comply with a certain section of the Residential Tenancy Act. This can be really useful, especially in times like this where tenancies perhaps can't come to an end, but if someone is doing something that is incredibly disruptive to the building, allows you to back up what you are saying with something from a governing body. And should the tenant continue with that specific activity, when we get to the next phase in dealing with this pandemic, where perhaps evictions might be allowed, you'll have really good documentation, very solid documentation that shows that you are able to end that tenancy because they didn't comply not just with what you were saying, but with an order from the residential tenancy branch. And we're going to kind of gloss over monetary orders, but in general, you can, of course, still obtain a monetary order through residential tenancy branch, and then we get to order of possession. Really quickly, before we get to that, if you're looking for the section in the Residential Tenancy Act about order to comply, it is under 62 of the Residential Tenancy Act, and it is subsection 3. And it says here that including an order that the landlord or tenant comply with this act. It's more common to see an order to comply applied for by a tenant against a landlord, but it is an option for a tenant as well, for a landlord to apply against a tenant as well. So that's something that's really important to be aware of. We then get to end of tenancy as an option. And we didn't list it earlier in our options because to many people it feels like that's off the table. And in many cases, end of tenancies are off the table. But there are still a few situations where you could end a tenancy. And you can find that information in section 56 of the Residential Tenancy Act. But essentially, end of tenancies are still in place and enforceable in situations where really an emergency exists. The tenant is doing something that is so significant that this tenancy can't wait for a normal end of tenancy process, even outside of COVID-19. And it would be unfair. And that's specifically the words that they use. It would be unreasonable or unfair to the landlord or other occupants of the residential property to wait for a notice to end tenancy under the section 47, which is the 1-month notice. So what does unreasonable and unfair mean? Well, it means that they're perhaps doing very, very significant damage in the property. Perhaps they have repeatedly attacked other tenants, or even just singularly attacked one of the other tenants in the building. Those are things where violence really necessitates quick action. So the Residential Tenancy Act has a solution for that. Again, that's rare. The rules on this are significant. The test is high. You need to make sure that you have all your evidence ready in advance. before you actually go through that process. You can find more information about that at the Residential Tenancy Branch website, as well as of course the LandlordBC website. We have quite a bit of information on this topic. So that ends my presentation. I'll hand it over to Amanda.
Thank you, Hunter. That was really great. Now I'm just going to get somebody to confirm that you can hear me. I am joining in a non-standard way today, so you don't get my video and I can't wave at y'all, but thanks for being here today. I'm going to remind people that they can start putting questions in the chat box. Just in case you have questions for Hunter, once I've done a whole bunch of talking, I don't want you to have forgotten those questions, since we'll circle back around so you can ask questions of both of us as we get further in. So I'm joining today from Mediate BC, and I'm a mediator and the program manager for the new Quarantine Conflict Resolution Service. And Mediate BC is a nonprofit funded by the Law Society and the Government of BC that holds rosters of experienced qualified mediators in a whole bunch of different fields. We have mediators all over the province that do both family and civil, and most of the things that we talk about when we're speaking about housing is civil disputes. Next slide. So you'll hear me say next slide a whole bunch of times because Hunter is being very lovely today and running the PowerPoint for both of us. So what are housing conflicts? So there's a number of things that are coming up, and they've all been magnified by COVID and the current pandemic situation. So the first is shared spaces. And so these can be within units themselves or within buildings, and anywhere that people are trying to figure out how they navigate elevators, lockers, mail rooms. And then within units, families or roommates who are trying to figure out how to all be at home at the same time together. And so we're having a number of things coming to our attention around the kinds of conflicts that are new for people. So two people working from home are having to share Wi-Fi. Whose work meeting is more important? Who is allowed to be on the internet while I say I'm delivering this conversation with you guys? There could be someone who, you know, perhaps is supposed to be on a Zoom call, or a kid that's supposed to be joining a school meeting all at the same time. And most homes don't have the bandwidth to support that. There's a lot of family matters that are coming up. These are co-parenting issues, co-parents that may have had things that were working very, very well before the pandemic situation. Maybe their co-parenting arrangement isn't working now. Parents and teens are struggling. Teens are finding it very, very hard because their peer group is so important to them to be separated. And we're hearing a lot about elder conflicts. So families having very strong opinions about potentially what their parents and their beloved elders in their community should and shouldn't be doing, how we're handling entering homes, groceries, supporting elders that are physically isolated. We're having a lot of neighbor disputes and neighbor conflicts as well. So this may be, now that we're all home, how we are in our spaces is really impacting others. So you heard Hunter mention earlier the 5 a.m. blender. Maybe it's an 8 a.m. blender, but you can now sleep until 10, right? That 8 a.m. blender would never have bothered you because you were out of the house. So a lot of neighbor disputes are coming up where people are cooking more from home, people are using their decks in ways they haven't used before, they're making noises. You might have worked from home before, but now you have people on all sides of you and they're a lot louder than they used to be. And so things that weren't problems before are now becoming issues. And then working from home creates its whole own set of challenges. When you combine that with anxiety, confinement, reduced supports, and so in a lot of nonprofit housing, we are hearing that the reduced support is causing some significant issues. People struggling to access food banks, struggling to access counseling and other supports that they had before. So this sort of reduced support for parents as well. So figuring out how to school from home raises stressing and anxiety and is causing a lot of things that maybe had been working to become conflicts and to become things that maybe we're just not handling as well as we would like to. Next slide. So what is the Quarantine Conflict Resolution Service? So our goal is to do rapid access, low fee or no fee, conflict resolution that is addressing new conflicts that have arisen out of the current pandemic situation. And we started this program because we were hearing about roommate disputes in Europe well before issues started here. So one of my colleagues, Sharon Sutherland, and I both have colleagues and close friends in Italy, and we were hearing about the kinds of disputes that were erupting there, and we thought, okay, we had better get something put together really quickly. And so we started to spool up this program as quickly as we could. When we announced it to mediators, we had 40 mediators from around the province step forward to say, yes, we will provide low fee and no fee mediation services to support our community. And so we do have and civil mediators from all over the province, including those in some rural parts of BC with a wide variety of experience around housing conflicts and other types of conflicts. Next slide. So eligibility. And two pieces are pretty obvious, BC resident and willing to participate. So as I've said a little bit already, mediation is, it's voluntary. So people come willing to participate, and both people have to be interested and willing to at least start the conversation. The third piece is this conflict related to COVID. And that's a pretty gray area. It's not always so obvious what that means, but the kind of things that tend to sort of rule conflicts out are things that had been started before. So if you have an ongoing eviction process, if you had a divorce proceeding that had been started before all of this stuff happened, then that would fall outside of our scope. However, if you had started a divorce proceeding, but now things are in a fuzzy space and you have to kind of figure out how you're going to handle the next 6 or 8 weeks while your divorce dispute continues, then potentially one of our mediators could support you to come up with a plan to handle maybe how you'll continue living together in a shared living space until you're able to continue a separation, or potentially to figure out if an eviction process had been going forward, how you will handle the next 6 weeks, 8 weeks, 3 months, whatever that looks like together. And so there are some cases where there might have been a little bit of a problem, but now it's a real problem, and we can support some of that as well. So the next slide. So how do you refer to the Quarantine Conflict Resolution Service? So Mediate BC and the BC Nonprofit Housing Association had a discussion a couple weeks ago now about ways we can support nonprofit housing groups. And one of the things we came up with is that to do a streamlined referral system from staff and from building management. And so if you're finding that you have residents in your building that are having disputes, and the whole range from family to neighbor, roommates, even between tenants and building staff or building management, you can refer to our program. And you get verbal permission from both people or 3 people. I think the most we've had in a dispute so far is 5 unique parties. So we can handle multi-party, but the vast majority of conflicts are between 2 different clients. That's most of the time. Conflicts tend to be binary, but we do have bigger ones. Verbal permission from both clients, and then you send us an email, and that email will go to lobono@mediatebc.com. It just, in the subject line, QCRS referral, and then your building name so that we can track. Every once in a while, we get clients also coming through our regular system as well. And so both of those together, and then including in the body. Oh, next slide. Looks like we popped back for a moment. Thank you. And then just names and contact information, and potentially just a little bit about whatever the conflict is about. It's useful for me to know whether it's a family issue, a roommate issue, whether like kind of who the people are in relationship to one another. That can be quite helpful. And so next slide. Referrals really matter. And so the hardest part is asking for help, and referrals normalize this process. And that's just really, really valuable for me to highlight here, is that when clients get referrals to the program directly, not only do they go through the program faster, but they're more likely to participate. And this increased participation rate creates a dramatic different outcome in the long run. So there's sort of two hurdles that we find for clients getting into our programs. And the first is both agreeing to come. Often it's really hard for people to admit that there's something going on. And so especially if they have to admit that there's something going on at a level that they would then be reaching out for help to a body they don't know anything about. So having a staff member that they're familiar with say, hey, I heard about this, I'd like to refer you, would you be willing? Is a very, very different ask than there's this thing out there, I think you should apply. And so it gets people over that first hurdle to actually getting into a conflict resolution program. And then the second piece that's important for everybody to know is that clients coming through the BC Nonprofit Housing Association program do not have to fill out our financial declaration programs. They're given an automatic fee waiver. And especially for clients who are struggling or whose finances just feel really scary right now, even if they have all of the information to fill out a financial declaration, and our financial declaration form is pretty straightforward, it is something that a lot of people really struggle to take the step to do. And so by removing both of those barriers, we find that clients have a lot easier time accessing the program. And so the referrals from your staff really do make a huge difference. Next slide. So what is our process? I get an email from you that says, hey, here are these two clients. The first thing I do is I reach out to them and I have a small conversation with them to make sure they understand what we're doing and what they've signed up for, to confirm that they're actually interested in participating. So people waffle back and forth. They'll think they're in, they'll think they're out, they'll think they're in, and that's very normal and it's really okay. Embracing a conflict resolution process is difficult. And so we expect a little hesitancy, and that's part of the process. I get enough information from them about what's going on to do a brief determination that it's actually safe, and then to match them with an appropriate mediator. So whether that's where they are in the province, whether that's family versus civil, family mediators have a very specific set of training for dealing with family issues. And so if it's between parents and kids or between co-parents within a family, it's very, very important that we're referring to a mediator with the specific skills. If there's mental health concerns or other pieces, we want to make sure that we're matching with a mediator that has the skills to mediate whatever the situation is. Once they're matched with a mediator, the mediator has private conversations with each party, and those are very important. They do a couple of things. The first is that we screen for safety and create safety plans. We mediate at a distance, and so that distance means that if I'm mediating between two neighbors and something doesn't go right, I want to have a plan with both of them ahead of time to make sure that whatever does occur isn't dangerous, or within a household to make sure that we're mediating in a way that increases safety and doesn't increase risk. And then the other pieces that private conversation does is it helps getting people into the right mind frame to participate fully in a mediation, to figure out what kind of things they might need to do, or we as the mediators may need to do to support them to participate effectively, whether that's accommodations for disabilities, accommodations for styles of communication, power dynamics that have existed between the parties in the past. Mediators are skilled at figuring out ways to adjust the process in order to allow people to fully participate. and to really be heard and to be able to problem solve effectively. We usually do joint sessions. Joint sessions are conducted by distance, by phone or by video conference. Not all mediators use joint sessions, and not all clients are appropriate for joint sessions. So we do have the ability to mediate by text message, by email, asynchronously, where you have a conversation with one of them and then you have a conversation with the other one. Joint sessions are ideal, especially for people that will be dealing with one another in an ongoing way, which is often the case in housing disputes, where you're hoping to do enough relationship repair that people can live successfully together in the long run. And they don't always work. So it is really one of those things that we try to get to. Agreements that are made are captured by the mediation team in a way that works for the clients. And so sometimes we'll have people come in and really they just needed to have a supported conversation. There isn't necessarily any agreements about how they'll do things going forward, or they're kind of fuzzy, and they're good with that. We don't need anything all the way to drawn up formal contracts. Our program covers up to 5 hours of mediation services. So this includes the private conversations, the joint sessions, and any drawing up of any agreements afterwards, as well as some back and forth. So next slide. Okay, so quarantine conflict resolution service. Here's our contact information. If anything you've heard here is really interesting and you don't manage to slide a question in now, but you walk away and you're thinking, hey, for our situation, there's something I really need to know, do just send me an email at lobono@mediatebc.com and I'll get back to you right away. I haven't put our phone number here. Our phone lines are working, but we're of course all working from home right now. And so it's voicemail pickup and you'll get me much faster by email. So at this point, I think we're going to pass it back for questions. So if there's anything about your specific situation, anything Hunter said earlier, anything like that that you want to ask questions about, we'd love to be able to open it up and answer some of those questions.
Thanks so much, Amanda and Hunter. Those were excellent presentations. We have just a few questions here, so I'll start at the top and then we'll just we'll go through them. Again, as any of the participants that are listening, if they think of any further questions throughout this period, please don't hesitate to ask them, and we'll do our best to get to them. The first one, a bit more of a technical question, is quoting the relevant section in the tenancy agreement appropriate in a caution notice?
Sorry, you cut out. Is quoting the section from the Act?
Sorry, I'll repeat the question here. Is quoting the relevant section in the tenancy agreement appropriate in a caution notice?
Yeah, so that I'll take that one, since that is about exactly what I talked about. When describing what an issue is on a caution notice, and we didn't get into that. I mean, we could probably spend a full 25 minutes just on caution notices themselves. I would definitely always recommend putting things like the section of the residential tenancy agreement, common area rules, if you have them, the section of the Residential Tenancy Act itself. Being specific on those points is definitely helpful.
Awesome, thanks, Hunter. So this is a bit more of a direct example. Our organization is facing several instances of tenants experiencing mental health crisis, leading them to become hostile and aggressive to their neighbors or even damage property, all while refusing to communicate with their landlord. What are some ways we can support these individuals without calling the police or evicting them?
Well, I mean, I think this is always the really difficult thing, and this is regardless of whether we're in the time of COVID-19 or not. The tools that we have in general are always limited. And when it comes to residential tenancies, those tools are significantly limited. When dealing with situations like this specifically, I would always encourage having that conversation where possible. I mean, obviously we know that some people simply aren't willing to have that conversation. If the person has a caseworker, social worker that you're able to contact. Obviously, reaching out to them is definitely ideal, and trying to get that type of contact information in advance before you have an issue is really, really helpful. But it really just comes down to doing everything you can to communicate with them, and then handing it over to Amanda. I mean, mediation and offering that and having that referral.
Yeah, and there's sort of 2 or 3 things that I think are really valuable to think about in how those communications happen. The first is to start from a place of being really empathetic for whatever is going on for them. So I mean, nobody wants to be the jerk in the housing unit that's disturbing all of their neighbors. That's not anything that kind of anybody desires to be. And so to start with an empathetic frame of, you know, something's going on, you're obviously really distressed by it. Can we have a conversation to see if we can figure out how to solve it? Is a really good frame. And then to take that next step, that is, let me figure out who the conflict is with so we know who needs to be in the conversation. And then to say, hey, if we brought somebody in from the outside to support us, would that work? And every once in a while, to get somebody on board, you need the tools like the caution notice or that threat to call the police or those pieces to have somebody realize that what's going on is really serious and you don't want to take that next step. So we're hearing things like, I don't want to call the police. And so to say things to somebody and to be really honest, to say, I don't want to call the police and this can't continue. Can we have a conversation to figure out what we do instead? Right? You know, not everybody's aware of how their behavior impacts others, especially once they're really stressed or they're having severe mental health challenges. It's really hard for them to see how their individual behaviors could possibly be impacting others. And then the other thing that I think is really valuable is that, you know, we can't do this right now. And if we figure it out, we won't have to do it later. So we're hearing a lot of things, or at least I am hearing from a lot of tenants who are like, what's the point in paying partial rent? They're just going to evict me the moment the eviction thing is lifted. Or what is the point in talking with my landlord now? I know that when, you know, this stay on eviction is lifted, they're going to evict me. And so I say things like, well, how do you know they're going to evict you? What evidence do you have? Do you think that potentially that could be something that you have a conversation around? And so these spaces where we can talk about, you know, maybe they're going to evict you, but maybe they won't. And if you don't want to be evicted, why don't we have the conversation? Because the conversation isn't going to hurt you, right? It's not going to increase your risk of eviction. It might mean you make a plan where eviction's off the table. Does that answer the question?
Absolutely. Thanks, Amanda. I also want to mention just on this question, we have some more resources on the BCMPHA website for this kind of issue as well. We had a webinar done, I think it was about a week and a half ago with CMHA, who addressed some of the more personal aspects of conflict resolution between tenants as well. It was really excellent. So if you want to follow up on that question, feel free to take a look at our webinar page as well. But I think what Amanda and Hunter have both said are really excellent here too. So thanks very much. I'm just going to jump ahead here. There's one directly for Amanda, and it's that are resolution services available for COVID-related disputes between a client and the landlord, or is this service exclusively for client-client disputes?
This service is available for everybody in the province experiencing conflicts. So the fee waiver is for residents and tenants, but if as a nonprofit organization you needed conflict resolution services with a specific client, then absolutely. The referral process itself is slightly different. So in that case, just shoot me an email and I can talk them through what that process looks like. There's an intake form on our website as well for businesses. We do businesses, the whole gamut of stuff that is directly related to COVID, including issues around shared spaces for businesses reopening.
Excellent, thank you. This is a very, very specific question. It almost feels like a test question. So if either of you don't have the answer, no worries. But we had a question that came from someone in the chat that said, would a landlord have to cite Section 56 in the NTE in order to get an eviction during COVID?
So you don't have to cite it because you're not giving a notice to end tenancy. So I think the thing to be clear, when we talk about things like citing a section, you don't really actually generally have to do that. If you're providing a caution notice, that's one thing, but a notice to end tenancy, an NTE, the notices themselves, first of all, actually cite the section that is relevant. So if you're serving a 1 month notice, for example, it cites Section 47 for you. So it does that, and it goes on further to that as well. If what we're talking about is ending tenancy early, obtaining an order of possession for those emergency situations, you're not serving a notice to end tenancy in that situation. What you're doing is actually making an application through the Residential Tenancy Act, through their dispute resolution services, which is actually a form available on the RTP website that allows you to do that. You can do it through the expedited hearing process. So it's not specifically about citing it, the form itself cites it. So yeah, I hope that answers.
Excellent. Thanks, Hunter. That was a tough one. Good answer. If a tenant has damaged their suite, can the landlord charge them for repairs beyond keeping the damage deposit after they move out? So
I'll take this one again if you don't mind. But the answer is yes. You can go through a monetary order for anything above and beyond the security or pet damage deposit. Monetary orders are not they're not limited to just the security deposit. So you can go for higher. The limit to an order you can get through the Residential Tenancy Act matches that of which you can get through small claims court, which I believe is 25,000 at the moment. So that might be changing or has recently changed.
Great. Thanks, Hunter. Well, for now, that actually comes to the end of the questions that we've received in our chat function here. And so maybe I'll give another just couple of minutes here for folks if there's any other questions that come up to ask, and if not, we'll move to end the webinar a little bit early. And so I'll just hang on for a second. Oh, we've got a follow-up question. Great. So this is the same person who asked about the Section 56. So this will probably go back to you there, Hunter. If the landlord is not serving the NTE, but rather making an application, how does the tenant find out about the proceeding?
Good question. So whenever anyone makes an application for dispute resolution, they have a duty to inform the other party that there is a dispute resolution proceedings occurring. And that is done by serving the other party with the notice of dispute resolution. So that when we look at the process, just kind of really quickly, a landlord or a tenant for that matter, someone makes an application for dispute resolution. It doesn't matter what the situation is. You make the application for dispute resolution, and what you obtain back before you have the hearing, or after you make the application, is a notice of proceedings. And this notice of proceedings informs you of the time of the hearing, the number to call in, your access code, and also contains a few information sheets. The person who applies has to then serve that documentation on the other party. In general, it needs to leave your hands within 3 days of receiving that package from the residential tenancy branch, and that informs the tenant that this has occurred. Truthfully, if we're getting to a point where we're ending tenancy because the tenant has caused significant damage, they're being violent, whatever it might be, in the context of now and applying for an early order of possession, they're likely going to be aware already. There's likely already been conversations that have occurred. They'll be aware that this is happening. but then officially you let them know by serving them that documentation along with your evidence as well. So that's an important thing to be aware of, is that all of your evidence that you supply in this, which needs to be provided at the time of the application, must go to the residential tenancy branch and to the tenant.
Excellent. Well, I think that brings us to the end of our questions. We haven't had any other come in. So I guess we'll end a little bit early. And I just want to extend another sincere thank you to you, Hunter, and you as well, Amanda, for an excellent presentation and for your time today. And we'd also like to thank the attendees for their questions. As I mentioned before, we'll be sending the link to this recording and the visual recording piece to all the participants within the next few days. And the recording will also be hosted on the BCNPHA website at bcnpha.ca/education/webinars. For more COVID-19 resources and upcoming education webinars, please visit the BCNPHA homepage at www.bcnpha.ca. Thanks again, and take care, everybody.
Thank you for your time today.
Thanks, folks.
Thank you.